And the panel that we have this morning, which I'll ask John Evans to chair, is going to talk about the role and the impact of the media. A series of questions: when they call, do you talk to them? How do you talk to them? Can you use the media to make your case? Are there legal reasons why you might think that the media have more access to information than you might otherwise think at the start? For example, their use of freedom of information. And generally speaking, what do you do when you're looking after somebody who is now on page 6, or on the evening news, or on the 11 o'clock television program? John Evans, thank you.
Thank you. Herman himself should be chairing this program, I expect. Before we start here, I think it's appropriate to comment on the respect that I feel, and I'm sure the rest of you feel, for the panel you just saw. I think that in the year 2000, one member of that panel, if he's played it right, will be fishing full-time in Elliott Lake, and the other 3 will be on the Court of Appeal. It was quite a spectacular panel. On my right, on your left, we have a panel of people who are not so much of the legal profession. Eric Cunningham has done the extraordinary feat of moving from the world of politics, where he was an MPP in the provincial legislature, to actually surviving in an economic milieu and making a living as a public relations expert. He is qualified and experienced in giving public relations advice in the commercial world, but also in the professional world. On my left, Michael Fitz-James has brought dignity to our profession, in my view, by publishing and editing, now publishing only, the Lawyers Weekly, which I think we all share the view that there we have a media instrument which comes to us on a regular basis and gives us information which is useful and accurate and has a tone to it that's a pleasure to read. On my far left, Roger Oatley, who will be the president of the Advocate Society next month, has served this profession with great distinction, has just finished a principal trial involving the threshold in the Court of Appeal with Cherniak, others. But he's here principally today because he's a man who is very, very good at using the press. I was asked to chair this panel, and my principal approach to the press calling is to try and duck and avoid and give some explanation of the case, but Roger is astute and capable at using the press, and I think between the two of us we may be able to give you some alternate approaches to that, to the methods of handling the media in dispute situations. I want to ask Roger to begin in his paper and in the material. I think at the back of his paper, which is about halfway through the book, at at page D27, you'll find Rule 21, and I thought it would be appropriate, because this is what our governing society tells us to do. It's my sense that this is a rule that the Law Society are reasonably up to date, and so that there's not an issue before us in the profession of, well, there are no rules for us, there's nothing for us to follow. There is a rule. It has an appropriate, it is reasonably current. And Roger, I wonder if you could take just a minute or two to break out the rule.
It was interesting for me because when I sat down to try and create something worth giving you, I started out with what I called rule number 1 in my paper. And in a nutshell, what that rule says is that you want to have a clear understanding of the interests of your client, the interests of the profession, and your personal interests and that you reconcile those interests before you speak. It was after trying to articulate that for myself that I received from Laurel Evans with the Law Society Rule 21. And I was pleased to see that in my own attempt to craft something, I had become pretty close to setting out what you'll find in these 2 pages from the Law Society's Code of Conduct. Let me take you very, very quickly through it. The first part of Rule 21 tells us that we're to conduct ourselves when we're dealing with the media in a professional way and in a way that would not be considered improper. That gives us no guidance whatsoever, of course, with respect to what the standard is, but it does make it clear that the Law Society will consider it within our professional role when we are speaking to the press. The second part of Rule 21 appears to contain 3 tests. The first one being that you must be satisfied that any communication is in the best interests of the client and within the scope of the retainer. And I wonder if within the scope of the retainer is broader than a requirement that you have specific instructions to speak to the press. I don't know whether that's ever been argued or interpreted, but I would suspect it might, because so often you're asked on the spot to speak, and it would simply be impractical to have to go running to your client to ask whether you can respond to a question. The second requirement is that you be qualified to represent the client effectively before the public. That appears to me to speak to a standard of advocacy. And finally, that you're not to permit any personal interest or other cause to conflict with your own client's interests, a rule which I would have thought went without saying. And connected with that is the 5th rule at the bottom, and that is that we should not be using the opportunity to speak to the press purely to publicize ourselves. That is a form of personal interest which could conflict with the clients quite clearly. And the next portion of the rule is that the lawyer, when acting as an advocate, should refrain from expressing personal opinions as to the merits of a client's case. I want to confess to you that I'm not sure that I know what that means. We all know of perhaps the most famous case, and that's the Capito case. Ron Slaght and I were classmates of Harry's, and it was a tragic experience for him. You'll recall that his comment was that I believe the courts and the police stick together like crazy glue. It seems to me there's a difference between that kind of comment and indicating, as lawyers often do, quite properly and tastefully, that they regard the decision as wrong, or perhaps certain evidence wasn't considered, which will be raised in some other place. I'm not certain what that means, but I brought it to your attention nonetheless. The next section of the rule encourages public respect for the administration of justice, and you should note that we're held to a higher standard by this portion of the rule than we might be held to by the courts when the courts are imposing their own rules with respect to our comments with respect to the proceedings of the courts. There is in the commentary on the next page what might have been a 6th portion of the rule in the 2nd paragraph, where it indicates that it's proper to speak to the press so long as there's no infringement of the lawyer's obligations to the client, the profession, the courts, or the administration of justice. It sounds a lot like my rule number 1 and a bit of a summary of all of it. I won't take you through the commentary because I know John wants to get onto other matters. But the 5th comment is interesting because it's an acknowledgement that it's impossible to set down guidelines which would anticipate every possible circumstance. We all know that, and in the end, it's my suggestion to you that we have an obligation to ourselves, to our clients, to the profession, and to the dispute resolution body we're in front of to always act as you would expect others to act, and that is in good taste and in fairness. It would appear that as long as we do that, the Law Society has attempted for modern times to balance all of these ethical issues and has concluded that it's entirely proper for us to speak to the press, provided that we live within those parameters.
All right. Michael, do you...
Yeah.
Come on.
I just following up on Roger's thing. He says it's somewhat impractical to go to your client every time you want to talk to the press. Believe me, it's done all the time. When we phone people up, very often they'll say, let me check with their client. Quite often they'll talk directly and assume it's part of their brief to go and do that, and that's fine too. But it's done all the time, and I don't see anything wrong with it. But that's just my gloss on his.
I might just say one thing from a practical point of view. The lawyer can serve the function that quite often public relations people do in that circumstance, where deferring to your client to obtain guidance or direction from the client allows you the opportunity to be more thoughtful in your response and more strategic in your response. What we counsel clients quite often is not to take a call directly from the media, or if you do get caught, get their number, ask if they're working on a deadline, and commit and honor that commitment that you'll endeavor to get back to them. But by deferring to your client, and the requirement of Rule 21 actually probably gives you a legitimate reason not only to get back to the client, but to make sure that when you do get back to the person from the media, that your response is as thoughtful and consistent with your strategy as it could be.
I agree entirely. I'm more often representing people who are the public interest of some school board or a university, and from my point of view, between my client and I always consider it essential for my relationship with that client that the client have an idea of what is going to be said. And usually, if it's a politician, it's the client who wants to speak. If there's going to be a public statement made, it is usually the politician who wants to make the statement. But that provision in the rule gives you a very clear professional obligation that the press will understand. The thing that's critical is to pay respect to the professional reporter throughout the matter, find out what his deadline is, find out what his timing is, and deal with him and get back to him in a timely way. I'm going to just turn to sort of spice this a little bit. Michael Fitz-James is not just a man of the sedate Lawyers Weekly, he is also a man of the soft pulp press. And I want to just talk, is there such a thing? Have I made that up?
The pulp press, not the soft pulp.
Soft, is there a porn word I've left out of that, do you think?
No, I'm not involved with soft porn.
No. Talk to us a bit about the kinds of cases that attract media attention. Obviously, sex and fraud are attractive today. Is there a potential that the issues of complex commercial negligence that interest us more, professional competence issues in other trades, professions,
yeah,
are those likely to become interesting to the press in the future?
Well, you have to, I've been a television reporter and a daily newspaper reporter, and mostly the bulk of my journalism career has been in professional publishing, and I look at it from a slightly different angle, the way we do it in Lawyers Weekly, and now lately the Bottom Line, which I'm now also publisher of. It's the newspaper for accountants. The way we look at it is we're looking for these kinds of cases involving professional discipline for essentially moral object lessons for the profession, and believe it or not, administrative law issues, because we have quite, as you all are aware, we have quite a heavy coverage of law, qua law. In fact, that's probably why you all buy the paper, because it's useful, because it gives you that ongoing jurisprudence. In any newspaper, there's a function, and it's not the publisher. There's a person whose function it is to taste the stories as they come in and to assign them out to reporters in some way. The Star, it's called the assignment editor. In our place, it's actually the editor, because we have a smaller news flow. And where we get that from and the decisions we make in order to follow up a story, we have a different set of criteria than the Star does. The Star wants to see sex and things that interest their readers, you know, naughtiness, criminal conduct, that kind of thing in their professional discipline stuff. And we want to see basically lessons that the profession, lawyers, can derive from it, and as I said before, legal issues. Now, what we get, the Law Society, I really have to commend the Law Society, because they are a leader in terms of informing the press about what they do. And it has not been a bad thing for lawyers. I think it's been very good. I've got this, I haven't got a paper prepared here, mostly because I'm too lazy to prepare one, but I did make an issue of, make a handout here of some various pieces, clippings and various things, including there's a typical, you can see a typical disciplinary hearing when it's, you know, when notice is given to a newspaper about a discipline hearing, this one involving Carol Curtis. And it's the kind of thing, the Globe and Mail will get what this is here, this long sheet. This is actually what we get. This is a copy of what we get from the Law Society. I don't know whether you guys see it or whether, but this is what we have. And you'll see in here, if you look through it, you'll see that an editor, this is not my writing, but that's the editor. He's actually gone through this case, and there's about 20, 30 cases on it. And you'll see that there's actually 3 that are picked out. And the criteria that seems to have selected these 3 seem to be the fact that they're just longer than everything else. And they seem to involve some issues of misfeasance or malfeasance, or there's some greater level of tension and greater level of something we can communicate to our readers. In any event, we didn't follow up any one of these stories when we actually sat down and got down to doing stories on them. We didn't do any one of these stories. And to the best of my knowledge, neither did any of the local newspapers who actually had this as well. The reason that we didn't do them is because we had other things to do that was of greater importance, the legal stories, and there just wasn't enough space to cover this. The Law Times, our competitor, I believe they routinely publish this, but the reason that they do that is because they can just typeset this. They've only got 1 staff reporter, we have 7. They only have 1 staff reporter, and they just typeset this. Bingo, it's free, it's cheap, easy. Anyway, there you go. And they have half our circulation too, so there you are. But this is going to come to an assignment editor who's going to make decisions.
He's the Paroian of my panel.
We're going to make decisions. Now, very often we won't even follow it up at this stage, where it tends to get covered in Lawyers Weekly. And I ask you if you could just turn a couple of pages earlier. You'll see what you've got here is what I've done is we offer a product every 5 years, and this is the 5th year. I'll put a little plug for it, called the 5-Year Cumulative Index for Lawyers Weekly. This is actually, it's not going to be published till September, but it's in proof stage now, and this is a proof, so you'll be tolerant of any errors and all these silly numbers on it and stuff. They're all typesetting codes. What I've done is I pulled out the proofs here of lawyer and accountant discipline and physician discipline in all the cases we've done. And if you look at them, what we tend to do is we tend to wait until it gets into the divisional court as a discipline issue before we do. We tend not to do it, with the possible exception of somebody like Harry Capito, where the Law Society was extremely accommodating on its information flow about Mr. Capito, and where as well the issues were exciting and dramatic and interesting for our readers. We do generally tend to wait until they come out at the divisional court where there's a legal issue that our readers will be interested in, as well as the kind of moral conduct kind of thing we want to communicate to them. Plus, as well, the utility of waiting for the divisional court is that you don't have to worry. There is some question as to when you're covering a discipline hearing as to the libel problem. You'll get people making statements outside court or outside the hearing, and you get into these sort of fuzzy areas where if it's at the divisional court and it's on the record, no problem with libel, bingo, in it goes. So keep that in mind. Now, the way various professional organizations communicate to the public. The Law Society, as I see, is a leader in it. I wish we could have the same kind of conduct on the part of the accountants and the doctors, the College of Physicians. I've enclosed here. I work as a columnist for the Medical Post, and I've enclosed a couple of stories here for regarding coverage. I also did some medical negligence and medical discipline issues. There's a story here called Doc Overcharged Lawyers for Report Suspension Upheld. I wrote this in somewhere in 1992, I think. But the interesting thing about the way the College of Physicians and Surgeons does it is if you look in column 5, just about halfway down the column, what happened is that they came out with this, the college discipline panel came out with this wonderful language about how the public has to know and the public has to know. We get on the phone and we say, well, can we have a copy of the decision? Well, no, you can't, because it's under appeal to the divisional court and we're not going to release it to you. But what about all this public language we say? Never mind, go away, shut up, click. So we send somebody over to the divisional court and they get the judgment, and so we get it that way and do it indirectly. But that's the kind of thing you're constantly meeting. The same thing is true with the Institute of Chartered Accountants, where, yeah, if you're hanging out in the hallway of the Institute of Chartered Accountants, you're going to find out what's going on there. But if you don't have a man or a woman posted down there, you'll never know. So we really have to commend the Law Society on that. Other things here.
I built my career on this, having fabulous witnesses. You ask them some question, they don't come anywhere near the answer, but they give brilliant responses.
Oh, I'm sorry.
You're doing wonderful.
I'm just trying to give people an overview of how we choose stuff. Another thing is we get an insight into how the Star selects it, because we happen to use a lot of freelancers, reporters from really all across Canada who are at various discipline panels and who hear about various discipline panels, and with the exception, as we said earlier, of Nova Scotia, they're all public now. We get an idea of what they want, and very often we won't buy lawyer discipline stories from freelancers, mostly because they just don't have any significant legal issue in them. If they deal with somebody, fiddling with their trust account or not keeping their books and records or not responding to the Law Society, this really isn't appropriate for a newspaper with our content and with our scope across Canada. We're not going to deal with somebody in a little town in Saskatchewan who doesn't keep their records in shape. It's just not worth it. Another thing you should consider, and this is maybe a tactical thing, is because newspapers don't cover everything on these lists that they gather, if you're representing lawyers at any rate, you might want to think about the wisdom of an appeal. Because when there is an appeal to divisional court and the divisional court issues written reasons, that essentially gives the press another kick at the can with your client if you're on working defense here. You're going to basically have another set of written documents and public documents which newspapers can report on, and very often appeal sort of ups the ante a little bit and makes the case a little bit interesting. So it's more likely that we will report an appeal than we'll report a discipline hearing.
Okay.
Yeah, I have some tips on how to talk to the media. But
No, we'll come back. We'll come to that. Yep. Eric, your framed question goes something like this. I think that the legal profession, counsel, don't have a lot of experience with how to use, what to use, when to use public relations people. We're trying here to direct ourselves to the issues of professional. The probability is that there are going to be one of two cases. Paroian and I might be acting for somebody who's earning $150,000 a year, is moderately successful in some business. Crane may be acting, or Slaght may be acting for a firm with a gross income of $14 million. And I don't mean that. Those are both very respectable professional organizations, both equally as good in their own community. And there is an allegation out there now that is either, for lawyers, is most probably fraud, or some part of that, and with medical and those other, maybe to do with sex. What use, how do I use, when do I use your type of public relations firm, and what's it likely to cost my client, and why? And so in the $150,000 case, in the large case. Does that?
Herman has cautioned me to get into costs and has threatened to fine me $50 if I throw my phone number in, so I'm not going to get into that. What I would endeavor to say to you is, in approaching this, I've looked at this not just from the focus of the individual professional who's under attack, but also from a firm perspective. And our firm has been engaged, frankly, on both sides. And sometime off the record, I'd like to talk to Mr. MacKenzie about some of the issues that we've been involved in, that he's been vitally involved in. We look at these things in a holistic way, and we think that an integrated strategy, where it's required, is very purposeful. I found Mr. Laskin's counsel this morning to be very, very useful in terms of being timely, demystifying things, keeping things as straightforward and as simple as you possibly can. And in an ordinary case or an average case, you may not need people like us at all, and I would tell you directly if you didn't. If it's a case where I think of one that we were involved in, incredible malfeasance on the part of a practitioner who has since bitten the dust. What it also said to me was that what kind of administrative standards exist within this organization? And that calls into question the entire reputation of the firm. I'm amazed, quite frankly, at the legal profession how cavalier so many of them are about their reputation and what we call reputation management. I mean, the law firms, whether it's a reputable but smaller firm in Windsor or one of the large firms, that's an incredible value. The reputation value is the sum total of what everybody in the firm is doing by way of professional services, charitable endeavors, their daily contact day after day. I mean, when you see when I go through these big towers downtown Toronto, I see the evolution of the law firms with the letterheads on the walls. I think, my goodness, the time and effort that's been spent by people in building up those reputations. We look at it from a preferred outcome point of view. It depends on who the client is. If the client is the firm, then obviously there's a different tactic or strategy that's employed. If it's the individual lawyer, then possibly, even if the lawyer is guilty and likely to be convicted, then the preferred outcome might be a rehabilitation strategy. And I think it's encouraging that the Law Society have taken the view that these aren't life sentences, particularly when you contrast what you can do in a criminal code offense and how quickly you can get out these days in this country in terms of punishment. So we look at what's the preferred outcome, what do we have to do to get there for the client, and how are our respective disciplines going to be employed to ensure that that becomes a reality. I worked on the Exxon Valdez oil spill for the pipeline. We had a preferred outcome. We had a wish list of things we were hoping would happen, and some that wouldn't happen. It was an integrated type of approach. In terms of the costs, most of the more reputable people in our business have an hourly rate that they publish, and fee negotiations are discussed in advance. I should say one more thing. We are not spin doctors. And I think that is analogous to ambulance chasers in your business. This business has evolved over the years to employ a much higher standard, and we counsel clients to be very, very straight with the media, not only to protect our own reputation with the media, but also to make sure that they don't come back and do a number on you. And most of these people, as I say in my submission, did not fall off a turnip truck. They're very, very capable, even in the smaller towns where it's a journalism student that's maybe just started with a smaller paper. That individual may be very talented, have a great deal of expertise, and may be anxious to get out of town by virtue of good reporting.
Tell me, just on that follow-up, I was interested in a comment we had in one of the meetings beforehand, and that very often it is not in the institution for whom a lawyer is acting, it's not in that institution's best interest that this litigation go ahead. The Hamilton papers recently, or right now, have a case going on of a sexual harassment charge at Brock University, and I'm shaking my head watching day after day after day of publicity about Brock University. And we still have the complainant in the witness box. But how do you work with lawyers and get lawyers off the focus? How do you tell Ron Slaght look, you may win this case, Ron. I've heard, yes, 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 and you got the client entirely convinced you're going to win the case. But where is Imperial Oil or the XY law firm going to be when the wound is healed?
I've been following the Brock case because we have an office in St. Catharines and because we know people on the board. And, you know, it's a classic case. It involves what we call the optics of things, how things look. And I can assure you that 99.9% of the public do not get into the minutiae, paragraph by paragraph, clause by clause, of what this issue at Brock is all about. They just do not get engaged in that manner whatsoever. What happens is they form in their own mind an opinion, which is the sum total of what they've seen on CHCH TV and what they've read in the Spectator or the St. Catharines Standard or what they've heard, and it may be very, very vague, but they may come to the conclusion that that institution is a bad institution, which I don't believe it is, incidentally. And that's the optics of things. It's how things look. If you look at the front page of the Star today, you see Liz Barclay of the Teachers Union, if I may call it that, and Sid Ryan of, is it CUPE? They're jumping up and down, full color shot. It looks like they won the 649. Now, is that the kind of image that you want to convey? If I were counseling, I would want to have them quite tired looking, quite frankly, haggard. Sid's got some nice suits, I know. I would want them to be concerned about how we made our best effort. We tried, it broke down. And that's contrasted with stories on CBC where the negotiating team on the part of the province is alleged to have been in tears. They were so disappointed that they came that close to negotiating on that. It's the optics of things. I would be concerned in the Brock case or any other case that we get into black letter law at the expense of reputation management. And those are decisions that I think are thoughtful, strategic decisions that you've got to make, and sometimes with other disciplines, not just law.
All right. Now, what I'd like to do now, we're about halfway through the panel. I would like to have a discussion, and Roger, perhaps you could lead it off, or with respect to what might be called the 30-second bite, or what do you do upon receipt of the unexpected call? I don't think anything is more seizing than that you're sitting there worrying about whether or not this statement of claim will go out, and the phone rings and it's so-and-so from the Toronto Star, and Mr. Oatley, your client, Dr. So-and-so, you're representing Dr. Oatley, Mr. So-and-so, Dr. So-and-so, and there are 17 people, I understand, who have been molested by your client. What do you say about that, Mr. Oatley?
I have no idea what I'd say. I'd say
Well,
you got the wrong lawyer. My friend and colleague Bill Leslie's up there from Barrie, and he and I know, as some of you may do if you're from outside of Toronto, that if you're in a small center, you get contacted by the media a lot. And it may not necessarily be about a discipline case, but you do get contacted, and as John said earlier, I've through the School of Hard Knocks found a couple of things that work for me. I've discussed them, by the way, with Eric and Michael, and I'm not sure that they're going to agree with me. First of all, though, with respect to John's specific question, I think it's just the same when you're negotiating something and another lawyer calls up. The last thing you want to do is start talking before you've determined what your message is, and if at all possible, obtain specific instructions. Always, unless you're expecting the call, beg off or don't take the call. Have the receptionist indicate that you're tied up and call back. I think that's a very important thing to do, but as I mentioned in my notes, timing is everything, and if you want to communicate some message, you better be prepared to get back to that reporter very, very quickly. Reporters operate generally under extremely tight deadlines, and if you get a phone call, it usually means Not always. If a feature is being done, it's not the case. But almost always it means, because the deadline is right around the corner. If you get the phone call at 10, it probably means that by 12 the story has to be in. So if you don't get back to the reporter very quickly, your side of the message may not be communicated. I've outlined some very practical tips, just a few of them in my notes. And the first one is that you have to know your message. And if you go to an Advocate Society Institute course on advocacy, if I've got the phrase right, we're told that we have to know what the representational theme is for our case when we're standing up to present it. It seems to me that's a very useful concept to have in mind when you're going to deal with the media. Unfortunately, stick together like crazy glue got Harry Capito into a lot of trouble, but it was a very powerful representational theme. If you can think of a good and appropriate one to use, it's a very effective way, as we all know as lawyers, to communicate very quickly with the media what it is you're trying to say in a way in which the public receiving the message will understand. I've also suggested, John, that you need to think about the differences between the various mediums. Television is a very interesting one, and the experts in these mediums will tell you much more than I can as a person who's had to face a camera from time to time. What will happen in my experience is that they'll come to your office or wherever, and the tape will roll for a long time. But when you see it later on the news, if you catch it, there'll be 15 seconds out of the 15 or 20 minutes that they spend in your office. And after that's happened for a few times, you realize that if you want to communicate a message, you have to do it over and over again every time you're asked a question in the interview. Eric will tell you that reporters are very skilled and adept, and in my experience they are, and they're extremely bright as well. But if you're careful, you can answer each question, in my experience, by always returning somehow to the message that you want to communicate. And from my experience, you simply have to do it if you want what's on that short bite on the television news to be your own message. You're the one being interviewed. Don't behave as you would in the Court of Appeal, is what I'm suggesting, and respond in an honest, intellectual way to the answer. Make sure you keep giving the answer that you want to communicate. The radio medium is, in my experience, often someone telephoning and they want to put you on tape very quickly. I'm always nervous to know when I'm chatting by way of background and when the tape is running.
Always running.
I was just going to say my rule, although I didn't express it here, is to assume that it always is running.
Always running.
Thank you. And I guess my rule is a safe one. But the same, I think, applies to the radio. Know your message and communicate it over and over again. With respect to the printed press, my experience with these people is that they're incredibly busy. They're under awful pressures. They have many people to talk to. You want to, again, know your message, get to the point quickly, and it's very helpful, in my experience, to give the reporter something in writing which contains the facts, expresses your point of view. Very often, I've seen whole paragraphs from that kind of document lifted and put into the paper. And I think you need to know, John, where the story is. As Michael was saying earlier, you have to have something if you've decided you want to get a message out there and you're not trying to avoid publicity. You've got to have something which distinguishes your own client's case from the vast array of stories that there are out there. We have a tremendous number of newspapers, radio stations, television stations in this area, and to get something heard, You really have to find out what's different and be ready when you're contacted by the reporter to inform the reporter quickly and try and educate the reporter as to what the interesting angle is, which will make it a story that will not only get written, but get past the editor's desk so that it's communicated. And I'll conclude, because John wants to get on to other people who know much more about this than I do, by the way, with what might be the most important suggestion that I would make. And that is, you have to be honest and upfront with these reporters. For one thing, they are very, very canny people in my experience, and like good lawyers, they have a sense for what the truth is and what the real issue is, and they'll see through you very quickly if you're not being straight, and you'll end up with egg on your face. But the other reason, and it's probably obvious, is that we all hope to be around for a while, and it'll haunt you if you weren't straight the first time, because it'll be remembered. And on the other hand, if you are straight with the media, and in a small town, some of you like me are from small towns, I'm sure, or if you're involved in a number of high-profile issues where the press will be back to you time and time again, every time you earn some points, it'll stand you in good stead the next time. But every time you lose a few points, you dig yourself a deeper and deeper pit from which to climb out. That's very quick and dirty, John, but I hope it gets it started.
I think I'm going to just take a minute and give you how I see some of that same issue. I think there are really 4 situations you may be confronted with broadly. There's the case where you have some personal interest in getting a case or an issue out there in the press. And we're really not talking about that. You want your case to be publicized because you have a case against the big industrialist and they're polluting your client. Or perhaps you're a lawyer who wants to build your career and get known in your community. We're not talking much about that either today. You maybe get a call from the press. Patricia Jackson, the Human Rights Commission have just ruled today that women aren't persons. What do you have to say about that? Or stuff like that. Public issues where you get called because you're known in your community. And again, we're not talking much about that, but some of this same thing applies, that if you say to a reporter, that's a very interesting question, but you want a brief and reasoned reply, I'll call you back in 5 minutes because I want to think it through. And I've never heard a reporter who wasn't delighted to have you do that because you're cooperating with them and you're helping them with the story. I think I said there were the third and fourth things, it seemed to me, is that a reporter may be calling you about a story that's ongoing and is of no particular inflammatory interest. And the fourth is where the press are really onto something. And I got a brush of that when Pocklington almost moved to Hamilton last month. And you suddenly get the Edmonton paper, the Toronto Star, the Globe and Mail, the CBC, and it's a whole new world for you when they are all calling and wanting to get anybody to talk. They're after the mayor, they're after the rink, they're after every... Mr. Pocklington said this, is that true, is this true, what are you going to do about that? And you really do have to get a hold of who you are and know what you're going to, how you're going to, what role you're going to play and respond. It is my view that often the best thing to do is to take the call, to listen to the question. What I do, what I do is to say, all right, can we go off the record for a minute? Now, my purpose often, if there's a story just breaking, somebody is charged, my purpose is I want to keep my name out of it if possible, because I don't want the story to be Mr. Jones's lawyer says. I don't think that looks good on my client. I don't think that looks good for the judge that's going to hear the case. I think it's best that the story appear about facts. So what I will do is get him going, and I don't mean I'm manipulating him. I want to know what his story is. Then we talk, and I say, yeah, well, that's interesting that such and such has happened, but of course, we'll be drawing out, or I may talk to him a little bit about a defense theory or some way that will be interesting. Now, what I'm looking to do is to get in that opening story a balanced story, so that what is not just published is a burn down a schoolhouse, but that whatever the other side of the theory might be, that what the press, that the first, because that story will probably only run once. If you answer it, then that story may die off. You given it's sort of a half-balanced story, probably 2/3 against you and 1/3. That's okay, and away you go to your tribunal. That's the way I do it, and if there is a necessity to give some quote on a legal point, or that you try to keep that very focused, narrow, and give them their 30-second bite, whatever that is. That's the way I think you're better to do it. And I think that's about the end of what I have to think about that.
Now, John, I had one point I would make on that, and that is, depending on where you are, if you get a call from Rick Halichuk from the Toronto Star, there's no mythology. Rick Halichuk understands how this place works generally, how the disciplinary process works. If you get a call from, say, the business editor of the Barrie Examiner, he or she, I don't denigrate that paper at all, but he or she is responsible for managing all of the business press there, and would not be expected to be mindful of the processes such as they are here at the Law Society. And what you might say to that person is, are you familiar with if you're representing Mr. or Mrs. Smith, who's perhaps ready to face disciplinary procedures, you might say, are you aware how this process works? And then be very, very helpful to them with the process, and help them understand what the process is all about. I think if the press were more mindful about the process that Carlton Masters went through, which, and I take no side on that, I would only observe that the process was fundamentally flawed. The expectation of natural justice from that process was, in my view, Carlton Masters, former agent general in New York, who
Accused of sexual harassment.
and the case was washed out in the media. Tragic thing. I'm not here to carry the cudgels for either the government or Mr. Masters, only to say that the process was fundamentally flawed in my view, and an expectation of natural justice was not a real prospect. One other point I would make, and that's on big cases, and that is, you should engage a media monitoring service. You're too busy with your case. You're too involved. You've been up till 3 o'clock in the morning working on your brief. You're vitally imbued with what you're doing, and you cannot go through every morning at 7 o'clock in the morning everything that was printed from here to hell and gone about your case. And you need immediate access to what was said, because if there are errors or inconsistencies in the reporting of that, it is your obligation to expunge the record, to correct the record. Otherwise, with the data management systems we have today, it's in there forever. So that is something that you have to do.
You know, I've seen with Lawyers Weekly, you know, we don't just get our information from nice little handouts from the Law Society. It's quite remarkable where it all comes from. And very often the stuff we get on, you know, lawyers and alleged misconduct thereof is from disgruntled clients who haven't had who've had a disciplinary matter rejected by the Law Society, or they're from other sides, and there's a tactical thing. And I've often wondered, and perhaps Gavin, if he's here, could enlighten me, because we often get a lot of stuff from judges sent in, you know, cold transcripts that are sort of a day old, and the judges will send them in and say, this is a case. And of course, in there is the judge chewing out the lawyer and yelling at him and telling him what an idiot he is. And we probably are the first to publish that, or the first to get notice of that. And I wonder to what extent. Well, we get some. Yeah, we get, say, more than 10 a year.
Wow.
Yeah. And I often wonder to what extent, a lot of times just publishes them. We try and do a little interview with them. But I wonder to what extent.
That's 2.
Well, they're not here, eh? Or are they? Anyway, I often wonder to what extent those become the basis of disciplinary matters at the Law Society. I wonder whether the Law Society reads them in Lawyers Weekly and then starts an investigation because of that, whether they receive, or whether they actually have to receive a complaint. of misconduct. That's one thing. Another thing I wanted to point out is very often when John Evans is called, or Roger Oatley is called, the story's already been written. I mean, the story's there, and the reporter, be it on a daily or even on a paper like ours, are just trying to plug a live body into the story and get some quote to sort of make the story more readable. And so it doesn't really matter sometimes whether you think or not, but I certainly that's a real important thing though that everybody stressed here, is that for God's sake, and you see it time and time again, and every time I come to one of these meetings I say this, and nobody ever does it, but for God's sake, think before you speak to the press. I mean, keep in mind that tape is rolling the minute the person says, "I'm Jane Doe from the Toronto Star." The minute that's said, that tape is rolling, you are on the record. It's not a record like at a court where there's somebody typing it up. But that is what the record is. It's a very abstract concept. And think. Because, there's so much loose talk that goes on, and especially loose talk in a trusted media like ours. We're a newspaper that, in some cases, lawyers will only talk to our newspaper. And they think like we're pals and we're buddies, and they like us, but we're not pals and buddies. We're there to inform our readers. And we don't really, we like you, but, we're going to report what you say. So think about what you say.
There's one thing on the electronic side, and it is a classic mistake that people make when they're dealing with an interview. They're in your office, it's the camera, there's a little lady there, she's just done this nice interview, she's got the facts, there's Goofus there who's the camera guy, and everything's all done, and then turn the light off, camera stops, and you think, it's Miller time. I mean, I got through that, the deodorant didn't fail, I did focus on the things, and then our little charmer, who then enters into what we call the garden gate. It's the garden gate interview. And she just comes back through the garden gate, kind of like Columbo in the dying minutes of the TV show. She said, "I just had that one other thing I wanted to get into here." And this poor unsuspecting person thinks, now camera's off, everything's free, I'm off the record. And that's when the best stuff happens. And off the record, well, they're very courteous in Hamilton. I know from my experience in Hamilton, I only got misquoted once in 9 years. Tragically, it was a bad one. But in Toronto, they'll pin your ears back, and nothing is off the record. And if you don't want to read about it, on the front page of the Toronto Star, keep it on the record and keep it focused and be protected.
Could I just add a quick footnote to that? And it's from Eric's paper, but I've experienced it. You don't have control over what the headline is going to be above a story.
Neither does the writer, actually. Keep that in mind. Neither the writer does not write the headline.
And I once had a very painful experience of a poor choice of words. It was quite innocent, and I said it in front of an administrative board. But it ended up on the front page of the Barrie Examiner in headlines that were about 2 inches high. And it was excruciatingly embarrassing and painful, and it took me weeks to get over it. So I just want to underscore what Michael has said, and that is that every word has to be carefully chosen. And I, in fact, adopted a rule for myself after that experience that I won't say a thing to the press, even if it's off the record, if I wouldn't be comfortable having it on the front page of the Star.
One other thing. Your support staff and your secretaries. These are gold mines to smart reporters, okay? There's the very old reporter's trick. It's a very good interrogation trick. We don't use it, of course, at our newspaper, but others do. And it is to phone the secretary and talk as though you've had a conversation with the boss and you know all. And you talk with this sort of great authority and assumption, and you know bugger all, you know nothing. And the secretary confirms it. Oh yes, he said, and blabs on.
Ooh.
So, and that happens. That happens. So tell your support staff to shut up and refer everything to you. That's quite important, because we haven't gotten a couple of stories out of it, but I know people who do get things this way.
I'm going to defend the off the record, and I recognize its dangers. I still find it useful for myself to say, well, can we go off the record for a bit? And I find it useful to do what Eric says, and that is, there's usually some way that you can find to get into an instructive process with the reporter to explain what is the duty of somebody on an injunction application, or what is there is usually some issue which you can discuss that is not going to hurt you to discuss, that puts you into some kind of a role of assisting the reporter to get background for the story, and then you can work your way back around to deciding whether and what you may want to say about the questions you're really being asked. It works for me, or sometimes.
I didn't mean to be critical of that process, John. I think it's very worthwhile, but I still would prefer when I go home at night to try and sleep to know that even the things I've said off the record, if necessary, it's not going to embarrass me or my client.
Well, you've got to know you're the ones in the witness box. You're not in control.
The only time I got nailed off the record was in an election campaign, and we were in Ancaster, and it was a hot day, and this reporter from out of town said, "So, we're off the record here. What are the big issues here?" And I said, "Ancaster, keeping the pH right in the pool." And my campaign manager was not amused.
Well, it was too good. I'd have printed that too if I were the reporter. What do you think of when you'll see in my notes, when I was going to become president of the Advocate Society, I knew that within weeks I would become a national voice for advocacy and would change every reporter would be calling me hourly on all national issues involving law. So I talked to a guy named Jerry Patterson, who also is a public relations fellow of some peculiar reputation, and he recommended this book to me, which I sort of didn't read but have been through, and has chapters and I think all of these people will tell you can't manage the media, so he got the title wrong. But he does speak to how you can reach the media, and if you are in a serious media issue, I suppose a book of this type may be of some use. Do you know it?
I do. If the media think that you're endeavoring to manage them, they'll have their way with you.
Right.
They're not technicians, and the better that they are, and the stronger they are, the more you can anticipate that they'll know a lot about the case before they even get there. We did a plant closure one time, and every time I went to Ottawa, there was the guy from the Financial Post. He was like those guys from Butch Cassidy and the Sundance Kid. They were always there. How'd he get here? He knew more about what we were doing, quite frankly, than we did sometimes. So you cannot underestimate their intelligence, and if they think they're being managed, they'll get you.
Very often, just another somewhat unrelated point, very often professional newspapers are quite kind to the professional group they cater to. The Medical Post is a good example of that in reporting discipline matters. What I've done in this handout, I've reported the same story. One version was reported in Lawyers Weekly and publishes the doctor's name, and the other version we wrote for Medical Post, and they basically took the doctor's name and converted it to initials all throughout. So that to me was quite stunning. But I mean, it's basically their style. And the interesting thing about the doctor, though, this was the man who wrote a treatise on masturbation. When he read the story in Lawyers Weekly, he actually took out an advertisement in Lawyers Weekly advertising his treatise. So go figure.
So it's a couple of minutes before the end of the hour, so that apart from masturbation, we'll take questions on anything. A reporter wants to ask a question on the topic. All right.
I like that. Do you ever ask the reporter what the sting of his story will be? Because sometimes you're being asked questions and you subsequently see when the story comes out that the really negative parts have never been put to you. Is it a bad policy to say, what's the nub of your story, so I can meet it?
Well, I do that. I mean, I perhaps don't ask it quite as directly as that, but in my shuffling around and hesitancy and can we go off the record and what do you know, I try to search out what he knows, and he usually has something wrong. He says, well, I hear it's a mandator application by to the such and such tribunal, and you say, oh, yes, well, but I agree, I do try and draw out where he's coming from, and because I'm trying to build a paragraph into his story that is, in some way, gives it balance. What do you think?
Well, there are two views. There's an inherent, if they say, I hear that your client has sexually assaulted 4 women, there are 2 answers you could say. You son of a bitch, if you print that, I'm going to sue you on behalf of the client. That obviously often doesn't work at all.
Guarantees it'll get printed.
Well,
And
I'm not so sure about that, if it hasn't been formally announced and everything. But it's sometimes dangerous that if you ask the reporter for the nasty story that he or she's going to print, if you've asked, then you aren't entitled to say no comment. So it really is a real dilemma, because I believe that the reporter is obliged to tell you what the nub of the story is, if the story is going to react against you.
My experience with reporters is that the last thing they really want is a meeting with John Hondrick and their libel lawyer explaining why they've messed up. They're not keen about that at all. And if you can help the individual understand that they're off on the wrong foot, and I think John's sort of Hamilton-oriented, engaging way of getting people to talk to you would maybe serve you reasonably well in this regard. We had a case where they went after a fast food company where there'd been a fatality where a little gal had died of an anaphylactic reaction. Our position was, until we get the toxicologist's report, we just cannot be certain that the cooking ingredient to which you make reference came from our facility. And I would strongly, with the doctrine of fairness and accuracy and your reputation and that of your wonderful newspaper, really strongly urge you to defer to this until we get a little more facts. We got the facts in that case, and in fact, it had nothing to do with Kentucky Fried Chicken.
Oh, I agree with that, that I don't think you insult them, I mean, unless you have to, but that gracious sort of response, which is a veiled threat, I think is much more useful. Leon?
I just wonder if I can get a response on dealing with the professional from a smaller town perspective again. He received a letter from the professional organization saying there's been an allegation of sexual misconduct 10 years ago against you. At that stage, because I don't think we are necessarily equipped with the tools, no matter how good this lecture and this process has been, to go out and deal with the news media, should we be thinking in terms of calling in persons like yourself to get advice, I gather, rather than managing, on how to address the issue of the media? Should we, for example, go to the media first and say this allegation has been brought against Dr. Smith and make a presentation, or should we sort of hunker down and hide under the desk and wait for disaster to fall?
I think every case is different. It's going to be determined on its own merits. We got out in front of a disciplinary case one time from a media point of view only because we were terrified about what would happen if the other side got out and offered their point of view. Again, I think if you can help somebody from the Windsor Star understand that on any given day, anybody can sue anybody. On any given day, anybody can take something to the Human Rights Commission, which is really scary from my experience. I mean, it makes law society look timid in my view. On any given day, someone can claim that a gentle hug in a doctor's office by a well-meaning, somewhat older male physician who maybe doesn't understand the nuances of today but is a very gentle person and no impropriety at all. I mean, sometimes those are things that need to be managed.
But let's take that, the next question. Let's assume for a moment word has gotten out. The Star has reported it very accurate. Should we be then counteracting that? Because I think what happens with clients and with lawyers, we sit there flat-footed, be taken flat-footed, caught flat-footed. We don't know how to respond. We allow the adverse publicity to continue. We don't do anything about it. Should we be calling in a consultant like yourself to look at a countervailing tactic?
Herman, I said I wasn't going to do this. Yes.
I asked the question.
Thank you. I'll tell you, without getting into a law firm, I saw a law firm in this city get put through the Chinese water torture treatment, where a number of the senior partners in the firm were accused of covering something up. And my advice would have been, fess up when you mess up, agree to the best that you can without inviting a conspiracy, but agree on what the facts are and dump it out. And you could, not at press conference where this one feeds off of what that one says, and then this guy asks a question which elevates her understanding of an issue that she didn't know anything about until he said something, but a series of one-on-ones with the trades, with the Globe, with the Star, and you just push it right out. You dump the whole thing, and then there's a lot of reluctance in law firms to do that, but maybe at lunch I can think of a great case at Queen's Park where two ministers got in trouble on the same issue. One said, my comments were ill-advised, inappropriate, intemperate, and I apologize unequivocally. Media, up, over, out, end of story. A counterpart stonewalled for a month and just got beaten up day after day. And I guess it's a lesson for all of us.
Julian?
I just wonder if the panel's given a few instances of where lawyers can protect themselves on regard to the coming back in. And is there any other areas where protection can be taken? And I say it by way of example in a matter that I was involved in a number of years ago, which took an action and a motion being delivered to the CBC to prevent the story from being aired. And that was a situation where a politician, Minister of the Crown, gave an interview that was taped in his office, a very nice interview by the interviewee, very pleasant and so on. The minister then went off to his next meeting, and then all of a sudden staff noticed that the cameras were reset up. The interviewee started asking the questions. The demeanor and the way the questions were being asked by the interviewer, I should say, were completely different. It became obvious to the staff whatever was going to come over the news that night was going to be a slightly different type of interview than actually had taken place. I'm wondering if there are any other areas.
Well, in that case, if you'd had a tape recorder of the transcript of the interview, then to the senior producer, you would be able to make a great case.
Oh, no, we were going to do it by affidavit in any event. And they said, oh no, we have a right to edit the way we see fit. And they were obviously going to flash back and forth.
That's why we would never let a client go on 60 Minutes. Can't win. It's a no-win. It's a no-brainer. They call and say, well, I'm going 60. Guys are here from 60 Minutes. Lock the doors. You know, send in food. You know, just start painting the basement. Just don't answer them because you can't win with them. That's bad ethics in journalism and should be exposed as such. I mean, there's a standard thing where you have a one-camera deal and they do a cutaway afterwards. But contextually, the question to set up the already filmed answer should relate to what the original question may be. The man or woman may have stuttered a bit, maybe wants to tune that up a little bit, and I think that's acceptable. But contextually to change it, you were right to go after them. And moral suasion works best with the editor or the producer or management if you have to work it up that far. But I wouldn't hesitate to go to the court on it.
Can I just take 2 seconds to, I don't know if anyone else has ever been in a television editing studio, but I spent a night with an editor one night taking a couple of hours of material, mostly of Ralph Nader's speech, and crunching it down to about 20 minutes that could be given to people up at Queen's Park. And it was very scary. If you've ever seen it done, they have an ability to stop a tape, take chunks out, restart it, and reconstitute the tape, and it is simply impossible to tell that there has been any editing done. They can even take chunks and put it back into the middle of the original conversation and change the order of the remarks and materially change the context and the meaning. That's just by way of interest. If you've never seen it done, it really is quite scary. But I suppose in the end we have to trust that there is some ethics in among the journalists, and I'm sure there is.
I want to thank you very much for being a very attentive audience. I think in one final encouragement It's part of the fair committee. Years ago, a bunch of us were to be spokespersons for the fair committee around Ontario. And one of the media firms coached us. And it was, for me, and I'm sure for the other lawyers, an extraordinary experience. We have a belief that if you're asked a question, there's some obligation to give an answer that has some relation to the question. And to be told, to be sat and videoed, and you're asked a series of questions. So, aren't you just doing this isn't the fair committee really just set up to make money for lawyers? What we are looking for, ladies and gentlemen, is the best interests of the public and those persons who are the tragic victims of the road. You're nowhere near the question, and you do that repeatedly, time and again. And you watch the good politicians. Lloyd Benson always struck me as phenomenal at being able to seemingly take the question in, respond to it, and go right on his own agenda. Thanks, Herman. But you got to do that.
Turn it from facts to issues. Very good.
The one thing we haven't dealt with today is the use of the media when you're looking after the complainant. And the question might be asked, if you're looking after someone who is pursuing a professional person, what kind of resource do you have out there? Do you let them know about the complaint? Do you send a brown envelope?
People do.
I know that. I really, that's why I'm raising it. If your complainant comes in and says, the Law Society doesn't seem to be doing anything about this, or I think the College of Physicians and Surgeons is about to bury this complaint.
The secret to this is to always ask Turkstra the question, because he's got the answer. So what's the answer?
I don't have the answer. I'm particularly interested in Michael's
Well, I remember
response
when I practiced law years and years and years ago, there was always this person who comes in the door with like a foot-high stack of grubby documents, and they sort of haven't gotten justice somehow, and they become sort of obsessed with cases. But there's that person who's an obvious example, but there's a whole range of people down from that who are sort of exactly like that but don't look like that. So we as newspaper people we hope reputable newspaper people, and who are making money on our reputation, as you guys all are, we are very aware of that. And we have a file called the nut file, which is about that thick and full of grubby documents. And what we do is we invite people in and we listen to them. We thank you. Well, we'll think about that. And then we send them out the door into the nut file. And that's it.
You keep your own, you as a lawyer also keep a tape recording of the interview?
Everything word that you said to Lawyers Weekly and the Toronto Star and the Globe and Mail is on tape.
But should you keep your own recording?
It wouldn't hurt. I don't know about the ethics of doing that with your own clients, but I think if you're doing it with newspapers, it probably wouldn't hurt. Certainly the politicians do it all the time. Another thing you guys should remember is I think you can bill for the time you talk to the media, and it's, a lot of people don't do that, I think. You can bill for it. It's
What a morning. I just learned that if Evans and I get to be benchers and sit on a discipline committee, the divisional court for the first time in our lives is going to give curial deference to us. I mean, that is absolutely mind-boggling. I don't know how you feel about it. Thank you very much, John, the members of your panel. Show our appreciation. This afternoon we have Sex and Sin, starting with what to do when you're representing someone who is charged with immoral behavior. The thorny question of how you relate the disciplinary process to the criminal proceedings, where to find some money to help pay for all of this, and finally the insight that Bob Reid brings to this whole issue of what happens when you lose and you've got to go see a judge.